up at 15 minutes, okay? So you don't speak too long because our other speakers have to get on to do their other things. Oh, and I forgot to mention, I'm particularly grateful to David Bilshitz for speaking to us today because he has a deadline today. He's submitting a manuscript for a book today. So he took out time from his schedule today to speak to us despite the fact that he has to finish his manuscript today. So thanks, David, for that. So I'll pass on to Professor Khalid. Please, go ahead. The floor is yours.
Thank you. أرحب بالجميع. صباح الخير الناس الكل. صباح الخير للحضور سواء عبر البث الاحتفائية ولا الاحتفالية بالفصل 49 وبهذا المشروع مشروع إيديا حول الفصل 49 أن أجيب عن السؤال التالي: سنتان منذ انطلاق المشروع، أي تغيير؟ سأحاول أن أجيب عن هذا السؤال، ولكن اسمحوا لي في البداية أن أحول بعض مفرداته. سنتان منذ انطلاق المشروع، و7 سنوات منذ دخول، وقرابة 5 سنوات هذه المنظمة، منظمة إيديا، وكان لي شرف أن أكون الباحث الذي ائتمنني فريق إيديا على إنجاز هذه الدراسة. سنتان إذن، 5 سنوات و7 سنوات منذ الاهتمام ومنذ دخول هذا الفصل 49 إلى الدستور التونسي، وقد كان في المشروع عدده 48 في الحقيقة. قبل أن تقع المصادقة عليه كان عدد هذا الفصل 48. ماذا يمكن أن نقول وأي تغيير؟ يمكنني أن أجزم منذ البداية بأن الدفع الحقيقي للفصل 49 قامت به هذه المنظمة، قامت به إيديا، وسأثبت خلال كل كلامي صحة هذا الزعم. الدفع الحقيقي الذي قامت به إيديا للفصل 49 أحدث أثراً، وهذا هو المهم. أحدث أثراً على مستويات عديدة وسوف أتعرض إليها تباعاً. اهتمام إيديا بالفصل 49 جاء استجابة لوجود هذا الفصل داخل المنظومة القانونية ودخول هذا الفصل للمنظومة القانونية التونسية التي أصبحت تحتوي اليوم على ما عرف بكونه مفردة من أهم مفردات النحو الدستوري في العالم، مفردة من أهم مفردات النحو القانوني عموما في العالم. اليوم هذا المبدأ الذي يحتوي عليه الفصل 49 هو أحد المبادئ الكونية، يمكن أن نقول هو أحد المبادئ المنتشرة في العالم، والتي أصبحت تجيب عن نموذج من نماذج التفكير القانوني في العالم. بدأ تطبيق هذا المبدأ في سويسرا منذ أربعينات القرن الماضي، واتخذ هذا المبدأ شكله المعروف اليوم في ألمانيا منذ الخمسينات، ومن ألمانيا هاجر هذا المبدأ إلى المحاكم الوطنية في العالم وإلى المحاكم الدولية، فاستعملته المحكمة الأوروبية لحقوق الإنسان، واستعملته المحكمة الأمريكية لحقوق الإنسان، واعتمدت عليه المحاكم الكندية، خليني نقول مش كان المحكمة الدستورية، المحاكم الكندية والسويسرية والفرنسية، ولو أن هذا المبدأ في بعض الدول لا وجود له على مستوى النص القانوني، فإنه يمكن أن نقول أنه أصبح مبدأ عابرا للدول وعابرا للنصوص مبدأ من المبادئ الأساسية في التفكير القانوني. في تونس ظهر هذا المبدأ في الحقيقة بدفع من المجتمع المدني، خليني نقول من المجتمع العلمي، لأنه أذكر فيما أذكر أنه أول من طالب بإدراج هذا المبدأ داخل الدستور التونسي كانت دراسة قدمها الأساتذة سليم اللغماني وسلسبيل القليبي وسلوى الحمرور باعتباره ضامنا للحقوق والحريات، على عكس ما قد يبدو من الوهلة الأولى من أنه ضابط للحقوق والحريات ومحدد لها. إذن ظهر هذا المبدأ بدفع من المجتمع المدني، ووجد في آخر الأمر وكتب له أن يكون داخل النص الدستوري، ولكن دخوله كان دخولا صامتا. عندما اتصلت بمنظمة إيديا أول مرة لتشريفي بطلب إنجاز، احترت بعض الشيء، قلت إن هذا الفصل سيكون فصلا جافا بالنسبة لي. انطلق الفصل 49 في الوجود، هو موجود، ولكن لم يكن هناك تطبيقات للفصل 49، أو فلنقل أنه حتى وإن كانت تطبيقات، سأتحدث عن هذا فيما بعد، حتى وإن كانت هناك تطبيقات فقد كانت مبتسرة، تطبيقات مبتسرة précaire. فتساءلنا وتساءل المجتمع العلمي عن مجال انطباق الفصل 49، وأرى أنه هذه من الأسئلة الخلافية قد تكون في جل بلدان العالم. أنا ضد التحديد. يبقى الجدل قائما حول الكندية، ما حصل هو العكس. أول ما طبق هذا المبدأ طبق على القوانين، ولاغي أوكس معروف، ولكن أيضا في الألفينات تبلورت نظرية تنسب دائما إلى لاغي دوغي في كندا 2012 على اعتقادي، ويتعلق هذا بتطبيق المادة التحديدية، خلينا نقول في كندا، اللي هي المادة الأولى، تطبيقها على المقررات الإدارية وعلى أعمال الإدارة. إذن انطلقت إيديا من هذا التصور الواسع لتعطي دفعا كبيرا للفصل 49 قبل أن ينطلق القاضي في تطبيقه، قبل أن تنطلق الإدارة في فهمه، قبل أن ينطلق المواطن في الوعي به. انطلقت إيديا لوضع أسس مقاربة واسعة من أجل دعم الحقوق والحريات. ويقول الأستاذ جريم وهو حاضر معنا اليوم أنه من أجل دعم الحقوق والحريات يجب أن نكون مركزين على فكرة أن هذه الحقوق يجب أن يكون لها انتشار واسع، وأن ضمانها يجب أن يكون ضمانا واسعا. ما هو محتوى الفصل 49 وكيف تعاملت إيديا معه؟ لا يخفى على أحد أن الفصل 49 يتضمن العديد من القواعد، ولا يتضمن فقط مبدأ التناسب. فصل 49 يتضمن مبدأ التحفظ التشريعي، أي أنه لا يمكن التحديد من الحقوق والحريات إلا بنص قانوني بالمعنى الشكلي للكلمة، ولكن هذا النص القانوني بالمعنى الشكلي للكلمة يجب أن يحتوي أيضا على ماذا؟ على خصائص تميز هذا النص القانوني. إذن هناك خصائص شكلية للنص القانوني الذي يجب أن يحدد الحقوق والحريات، وهناك أيضا خصائص مادية لهذا النص القانوني. فالنص القانوني مع الفصل 49 لم يعد عملا سيدا، ce n'est plus un acte souverain. لم يعد عملا سيدا، هو عمل خاضع للرقابة على أساس هذا الفصل. التحفظ التشريعي. هناك أيضا مبدأ عدم التراجع الذي ينص عليه الفصل 49، ولا يجب أن ننسى هذا المبدأ، مبدأ عدم التراجع في مكتسبات حقوق الإنسان. إذن اليوم عندما نرى الصيرورة التي ذهب فيها مجال الحقوق والحريات وتكريس مجال الحقوق والحريات طيلة هذه الفترة، يجب أن نكون واعين بضرورة المضي قدما في هذا المجال. وهناك من المحاذير ما هو دستوري في هذه المسألة، مبدأ عدم التراجع. الفصل 49 أمان ماذا يحتوي أيضا هذا المبدأ؟ فصل 49 يحتوي على التناسب، هذه النظرية التي تمثل نواة الفصل 49. التناسب بفروعه، التناسب بوجوهه، إذ قد يكون عدم المساس من جوهر الحق، وهو شرط من شروط الفصل 49 عند تحديد الحقوق والحريات، يجب أن لا نمس من جوهرها، بغض النظر عن فهم الجوهر من عدمه ونظرية الجوهر في ذاتها. هناك أطروحات كتبت حول نظرية جوهر الحق، لا سبستانس دو دروا devant la Cour européenne des droits de l'homme، غوزيير كاتبة تيز كاملة معناها من 600 صفحة حول المسألة. بغض النظر عن هذا، يمكن أن يكون عدم المساس بجوهر الحق وجها من وجوه التناسب في ذاته حسب نظرية معينة. ما هو التناسب؟ هو الملائمة. ما هي الملائمة؟ هي العلاقة المعقولة من شأن هذا الحد أن يحقق هذا الهدف حتى يكون شرعيا. ما معنى التناسب؟ التناسب في مرحلة ثانية هو الضرورة بالمعنى الضيق للكلمة. ما هي الضرورة بالمعنى الضيق للكلمة؟ هو أن يكون القيد هو القيد الأقل تطفلا على الحقوق والحريات من أجل تحقيق ضرورات ضبطها الفصل 49 بطريقة حصرية. ما هي الموائمة في آخر المطاف؟ إذن الملائمة، الضرورة بالمعنى الضيق، والموائمة. ما هي الموائمة؟ هي ما يسمى أيضا في فقه القضاء الكندي تناسب الآثار، la proportionalité des effets، تناسب الآثار. هذا هو محتوى الفصل 49 الذي ركزت عليه المنظمة واشتغلت عليه. كيف وقع تطبيق الفصل 49؟ وما هو التغيير الذي حدث؟ حدث تغيير، خلينا نقول تغيير بين معقفين في فهم الفصل 49، لأنه لم يكن هذا الفهم، كان بالإمكان أن تكون هناك فهومات أخرى للفصل 49، ولكن هناك أيضا تغيير على مستوى قراءة الفصل 49 وتطبيقه. هناك القراءات العلمية التي أنجزتها إيديا، على الأقل هناك 10 مصنفات، هناك 8 أدلة حول الفصل 49. هناك كتاب عودة لهم العبد الفقير إلى ربه حول الفصل 49، وهناك أيضا كتاب في الطريق، هو كتاب الأستاذة كوثر دباش حول الفصل 49 والحريات الفردية. إذن هناك كما قال الأستاذ سليم الأغماني منذ يومين، هناك مكتبة للفصل 49، وهذه القراءة العلمية ضرورية، لأنه من الفقه سنمر إلى فقه القضاء، من هذا الفهم العلمي الذي هو ما هو إلا مقترح كما تعلمون. حتى على المستوى العلمي كل الفهومات العلمية هي مقترحات للتأويل. من هذه المقترحات خليني نقول فقه القضاء استطاع أن يتقبل هذه المقترحات شيئا ما، لأنه بعد تلكؤ في بداية الأمر لاحظنا أن هناك تطبيقات للفصل 49 على مستوى فقه القضاء. سأحاول أن أصنف هذه التطبيقات. سأقول أن هناك أحيانا نكران للفصل 49. أحيانا القاضي من حيث يجب أن يطبق الفصل 49 لا يطبقه، هو نكران إما ناتج عن عدم معرفة عن عدم تمكن من الفصل 49 فليكن. هناك تطبيقات خاطئة أحيانا، كلنا نعرف هذا القرار الشهير للهيئة الوقتية لرقابة على دستورية القوانين والذي أخطأت فيه تماما في تطبيق الفصل 49. هناك تطبيقات غير مركزة، أحيانا يكتفي القاضي ولكنه به جيد، القاضي خاصة الإداري يكتفي بالإشارة إلى الفصل 49 وحيث ينص الفصل 49 على كذا، ولا ينجز أي اختبار من اختبارات التناسب التي عهدها فقه القضاء في العالم. وهناك أيضا خليني نقول تطبيقات جيدة للفصل 49. مؤخرا منذ أيام صدر قرار بإيقاف التنفيذ عن المحكمة الإدارية بالقيروان بتاريخ 26 ماي 2021. تعرض فيه القاضي رئيس المحكمة الإدارية بالقيروان إلى ماذا؟ إلى تطبيق الفصل 49 وإلى عدم المساس بجوهر الحق وإلى الشروط الحصرية الموجودة باعتبارها ضرورات للتحديد من ناحية أخرى. إذن انطلقنا في ثقافة الفقه، الجملة الأخيرة زيد، انطلقنا في ثقافة الفصل 49 بدأنا نرسي ثقافة الفصل 49. مر الفصل 49 إذن من الفقه وهو اليوم في فقه القضاء، ونرجو أن يقع تطبيقه بكل هذا الزخم الذي طبق به في فقه القضاء الألماني أو في فقه القضاء الكندي أو في فقه القضاء الجنوب الإفريقي أو في فقه القضاء السويسري أو في غيرها من فقهات القضاء. ثم نرجو أن يمر هذا الفصل من فقه القضاء إلى ثقافة الشعب التونسي، إلى ثقافة الإدارة التونسية، إلى ثقافة المشرع التونسي، وهذا ما أظنه مجالا لعمل جديد في إطار هذا المشروع الذي شرفتني إيديا بأن كنت جزءا وجنديا من جنوده. شكرا.
شكرا أستاذي خالد لهذه المداخلة القيمة، وشكرا لالتزامك في الوقت كذلك أستاذي. I'm going to pass on now I'm going to pass on to Professor Grimm. كما أنتم تعرفون أنه Professor Grimm راح يتكلم في اللغة الإنجليزية، فاللي يحتاج ترجمة موجود أمامكم أجهزة للترجمة. إذا كان لديكم أي صعوبة، إذا أنتم مش سامعين العربي الترجمة، بس أعطوني إشارة، ارفعوا إيديكم، وفما شكون في أحد راح يجي ويعاونكم في الجهاز. لا تترددوا رجاء. I'm going to pass on to Professor Grimm. Professor Grimm, I haven't figured out exactly how I'm going to warn you about time, but if you could try to speak for 20 minutes, I'll be very grateful. Once again, Professor Grimm is a former member of the Constitutional Court in Germany, is a professor of public law, and is a fellow at the Berlin Institute of Advanced Studies. And I should also have mentioned as well that Professor Grimm has been to Tunisia and has participated in dialogue sessions about proportionality and Article 49 here in Tunisia as well, with colleagues from the interim Constitutional Court. So without further ado, I'll pass on to Professor Grimm. Professor Grimm, you have 20 minutes. Thank you.
Thank you very much, Mr. Al-Ali. For me, as a foreign observer, Article 49 of the Tunisian Constitution is a very interesting but also a quite difficult provision. The reason of the difficulties to me seems to be that this article borrows quite a number of elements from foreign constitutions and foreign bills of rights. And the relationship between these various elements is not clear from the outset. So before turning to proportionality, I would like to take a look to the ensemble of these elements in order to determine, as far as I can see it, the proper role of proportionality within this article. I distinguish 5 elements. Element number 1, limitations of fundamental rights have to be established by law. Number 2, no limitation may affect the very essence of a fundamental right. Number 3, the reasons for limitations have to be necessary in a civil and democratic state. Number 4, a number of goals that allow limitations are enumerated, and number 5, finally, is proportionality. The first element, a law is needed in order to limit fundamental rights, is common to all constitutions in liberal democracies. And I think there is only one question for me. Does any law suffice to fulfill the requirements, or only laws that are compatible with the Constitution? So are also pre-constitutional laws sufficient to fulfill this requirement? I ask that question because this was a big problem in Germany with the German constitutions of the 19th century. There were also laws required for limitations of fundamental rights, but any law from the pre-constitutional era was sufficient, and constitutions were rather irrelevant. The second element, the very essence may not be negatively affected by a limitation, this features very strongly in the German constitution, the basic law. The difficulty consists, in my view, in that it is extremely burdensome to define what essence means. Now, in Germany, the principle suitability is the law that limits a fundamental right at all able, at all suitable to reach its end. If it is not even suitable to reach its end, then this cannot be a legitimate limitation of a fundamental right. But I have to say that cases where laws fail because of this step, the suitability step, are, at least in German jurisprudence, extremely rare. I could mention more than 1 or 2 cases at all. But this is different with step number 3, the necessity clause. This necessity clause, the law that limits a fundamental right, must be necessary in order to reach the end of the law. This necessity, in my view, differs from the necessity in element number 3. In element number 3, reasons are required for limitations. In a civil and democratic state, here we deal within the proportionality principle, we deal with a means-end relationship. Limitations of law must be necessary to reach the end of the law. Not the reasons must be necessary, this is step number 3, but the measures that the law takes have to be necessary. In other words, if the purpose can be reached by a less intrusive means, then the law is unconstitutional. The legislature must employ the least intrusive means. A question of quite big practical importance is how does the court know that there are alternative means, and what does it mean? How does one know that there are milder, less intrusive means? Usually in a lawsuit, constitutional lawsuit, the party that challenges a law will name alternative means that this party regards as less intrusive. And the government will try to demonstrate that the means that they employed, that the means that the attacking party mentions are less effective. So the court has already alternatives, and the court has already arguments in order to decide this question of necessity. But if that is not sufficient, the court, at least in Germany, would invite expert knowledge in order to inform itself about the availability of alternative means and the question of necessity. And now the last step of the proportionality principle, proportionality in the strict sense, this is the balancing stage. The balancing stage is the most difficult stage and also the most contested stage of the whole measure of the whole business of proportionality. This is why still now the United States are one country, the most important country, that stays away from applying the proportionality principle, because there the opinion prevails that this is no longer a legal operation. This is, in the eyes of the American scholars and especially also the American courts, this is just simply politics and no longer law. I don't agree. I think it is still law, but it is still a legal operation if it is done correctly. And very often it is not done correctly. And here is a big danger, that judges introduce either subjective preferences or they introduce policy argument, which are not arguments available to judges, but judges work with legal arguments. So I think it is extremely important to exercise this last step, the balancing step, with utmost care. And utmost care means especially utmost care when filling the two scales. How to fill the two scales of the balance. In scale number one, one puts the fundamental right that is limited by law. In scale number two, the goal of the law that restricts the fundamental right is put. The next step will be to ascertain the loss for the fundamental right that is limited, and to ascertain the gain for the goal of the law that limits the fundamental right. And here, mistakes are very likely. I would like to explain it by using an example that played a big role in legislation in the last 20 years. Let's assume the legislature adopts a law in the course of the fight against terrorism. And let's assume that this law allows the interception of telephone conversations and of email communication in order to collect information on potential terrorist attacks. Now, it would be a mistake to put into one scale the value of liberty and to put into the other scale the value of security. This is the background problem. But this is not the problem that the case at hand, this specific law, presents. The case is whether this law is constitutional or not. And so the controversy, liberty versus security, is not helpful in applying the proportionality test. Another mistake would be to now compare the two values that are in the place, to compare the fundamental right of secrecy of telecommunication versus the value of preventing terrorist attacks. And behind the prevention of terrorist attacks, there are, of course, also fundamental rights, right of life of people who may be affected by the terrorist, privacy, property that may be affected. Now, why is it not correct to compare these two values? Because this is not what the law doesn't affect the values as such. The law does not abolish the fundamental right of secrecy of telecommunications, but it limits it in a certain and specific way. And this limitation has to be defined as precisely as possible. And the law does not prevent terrorism, but it gives the secret services a chance to learn about terrorist plans. And this also has to be defined as precisely as possible. Precisely what loses the fundamental right by the law that limits it, and what does the value in whose interest the fundamental right is limited, what does this gain? And only if this is done as precisely as possible, then one can hope to conduct the proportionality test in a legal way and not in a political way. An additional question that has to be asked is, does the limitation affect the core of the fundamental right? Then, of course, you have to apply the principle more strictly. Or does it affect only the periphery of the right? And then the question is, on the other side, how likely is it that the limitation of the fundamental right will really lead to relevant information for the secret services and the state. And if this is done, and again, if this is done as precisely as possible, then balancing is feasible, and balancing remains in the realm of law and is not politics. Two last remarks. If one, in this long list of requirements for a law that limits a fundamental right to be constitutional, if one requirement is not met, the law is unconstitutional and there is no necessity to continue with the other items of Article 49. When one of the prior elements are not met by the law, then the rest can be forgotten. And just because it was mentioned in the previous talk, in Germany we apply the proportionality principle twice. We apply it to see whether the law is constitutional or not, and we apply it in a second step to see whether the application of the law, the concrete governmental or administrative act, is compatible with the principle of proportionality. So far my remarks, and I hope they are helpful for the interpretation of Article 49. Thank you.
Hello? Yes, okay. Okay, thank you very much, Professor Grimm, for that. That was really terrific. Thanks you also for keeping to time. What I'll do now, without further ado, is I'll pass on to my colleague, is a leading authority on human rights law internationally, is currently a fellow at Reading University in the UK, is the former Secretary General of the International Association of Constitutional Law, is working strenuously to finish his manuscript today. So thanks once again, David, for taking time to speak today. And I should also mention that David has also been to Tunisia. If I'm not wrong, David visited Tunisia in 2013 and participated in a joint session that we organized, International IDEA organized with UNDP and the Constituent Assembly. And David actually delivered, if I'm not mistaken, a presentation on proportionality on that occasion, if I'm not wrong. So I'll pass on to David. David, you have 20 minutes. Please go ahead. Thank you.
Thank you very much, Zaid, and thank you very much for the invitation. And I remember, in fact, very well my time in Tunis, a very exciting time with the constitution about to be passed. And I must say I was delighted to hear that Article 49 was included. I hope you can see I just want to see if my presentation actually moves. Yeah, is it moving down?
Yes, it's fine. Yeah, go ahead.
Oh, okay, thank you very much. So, I'm going to be narrowing in a little bit on a particular aspect of proportionality. Just to start off with an introduction, fundamental rights, as a starting point, have a high level of importance, normative importance, and that's the reason they're enshrined in bills of rights and covenants. But as we know, they are not absolute, and they can be limited for objectives of a sufficient level of importance. And what we're dealing with here today is whether such a limit is a legal way, and to prevent it from being left simply to discretion. So there is a remarkable level of convergence, as we've heard from both Professor Khaled and Professor Grimm, across countries in their general approach to limiting rights, focusing on the proportionality test, and the courts essentially weigh up the importance and objective of the infringing measure against the harm caused to rights. And one of the key benefits of proportionality is that it is a structured reasoning process, right? And I won't go through this in detail because Professor Grimm has done that, but the first step is really to find an infringement of a right. And it's very important that that step be conducted properly, because one has to actually understand what aspect of rights is infringed. And essentially, this enshrines a presumption in favor of rights, that rights should not be infringed. And the second step then is really can the infringement be justified? One has to then ascertain a purpose, which is the key countervailing normative consideration, and then consider the relationship between means and ends. And you've heard about the suitability test, necessity, and balancing. And today I'm going to focus on that specific aspect, which I regard as one of the most crucial aspects of the proportionality test, the necessity inquiry, that it must impair the right as little as possible when achieving the objective. And that issue is something that has bedeviled courts a bit and is actually pretty complex. And I'm going to try and break down some of that complexity for you and actually suggest to you that we need to, sadly, but perhaps helpful analytically, break down the components of the necessity test more precisely. Now, Professor Grimm has taken you through Tunisia and necessity. And as he pointed out, necessity comes up in two places. Reasons must be necessary to achieve a closed list of objectives, and they are part of the proportionality test themselves. And I will consider them, I'm going to consider the necessity as part of the proportionality inquiry. I think Professor Grimm has laid out a very interesting way of perhaps distinguishing them, but I think that is obviously an interesting issue for academics to grapple with. Is there some difference there in relation to what the word necessity? So what are we going to do today? I'm going to look at why necessity is important. Then I'm going to set out what's called a strict interpretation of necessity. And that causes many problems for courts and leads them to adopt various avoidance strategies to mitigate the consequences of that strict interpretation. And I'm going to then suggest to you that a more reasonable interpretation is what we should call a moderate interpretation of a necessity. And that has four elements which I'll break down and I'll tell you about them. And ultimately, the point here is to recognize necessity as a critical element of proportionality, but to sharpen our understanding of what it means so that it is in fact useful and helpful to protect fundamental rights. And in doing so, I want you to keep in mind an example which, funnily enough, overlaps with the one that Professor Grimm gave you, but I'm basing it in a South African constitutional court case. And that case is called Amabungani Center for Investigative Journalism, and it dealt with the issue of surveillance of data, okay, bulk surveillance of data, so for security purposes, okay. And we will focus our attention in keeping in mind what I'm saying, because it can get a little complex in the details. We're going to focus on the issue of how long is it necessary for the state to keep intercepted data of private communication. So assuming there's a legitimate interest of the state in intercepting data, how long should it keep the data or archive the data? And we'll consider alternatives of 3 years or 6 years. You can substitute it in, but I want to just use that as an example to make it clear in your minds what I'm talking about. Okay, I'm just going to switch off because my interpretation device is giving me feedback, so I'm just going to switch that off at the moment so that I'm not getting feedback while I'm presenting. Okay, good. So what the strict interpretation of necessity. So the way in which the necessity test is formulated by courts, right, is often as follows. The German Constitutional Court says the following: a statute that violates rights is necessary if the legislature could not have chosen a different means which would have been equally effective, but which would have infringed on fundamental rights to a lesser extent or not at all. Okay? And the Canadian Supreme Court says the following: the means should impair as little as possible the right in question. Okay? So you hear little as possible, least restrictive. Okay? These are, now bear these in mind because they're going to play an important role in what we talk about. So, firstly, what is the point of necessity? Right? Well, in my view, it forces a consideration of alternatives to what the government measure is. And it ensures that even if the government has a worthy objective, right, rights are not impacted upon more than is necessary. Okay? Now, to make it meaningful, we need to ensure we have a proper understanding of the test itself. And the strict interpretation raises two complex problems. What do we mean by equally effective? What does it mean to say an objective is achieved equally by two alternatives? And when is a right impaired as little as possible? Right? When is it impaired as little as possible? Okay? And the problem with the strict formulation of necessity that you heard in these two judgments, the least restrictive means equally effective, is that it can be too difficult or too easy to meet. Well, let me explain a little bit more. Why too difficult? Well, judges can always potentially come up with an alternative, right? So that the government's measure will not pass the test. Okay? So, think about the government has 6 years, and the court says 3 years, and then you have 3 years and you can reduce it to 2 years, right? And Blackman from America said the following: a judge would be unimaginative indeed if he could not come up with something a little less drastic or a little less restrictive in almost any situation, and thereby enable himself to vote to strike legislation down. Okay, so the problem here is that one can relatively easily come up with an alternative, okay, that could achieve the objective, we'll talk about that, but have a lesser impact on the right, and then that gives judges the power to keep striking down the law. The law can never pass the test. The second problem is that the law may always pass the test. It's too easy to pass. Why? Because it's also often difficult to ascertain that measures are equally effective, okay, to achieve legislation, the objective of the legislation, okay? How do you determine equal effectiveness? And this, of course, requires you to construct the purpose in a certain way, but it's relatively easy for legislature to say, well, our measure is much closer to achieving the objective than the alternative, okay? We need 6 years because we won't be able to fight crime as much, we won't be able to fight terrorism as much if we would reduce it to 3 years. Okay? That's the kind of reasoning over here. So we have these problems in the formulation of the necessity test, and they lead to various issues, right? One is relates to the separation of powers. And here we have the traditional concerns of competence and of deference, right? The German Constitutional Court adopts a strict test but says courts have a limited power to review the legislative judgment that a measure is indeed necessary. So the shift focuses from what must be determined to who should be deciding whether the necessity test is met. Okay? And the result is that this reduces the force of necessity and widens the discretion of the legislature, which isn't a good thing for the protection of fundamental rights. It ultimately leads to abdicating limited or not. Either a limitation is necessary or not. It makes no sense to state necessity as a requirement, but defer judgment to the very body whose measures are being tested. Okay? Proportionality is a reasoning process designed to mean that the point of the test is partly lost. Deference also reduces plea into the question of necessity and when should they defer to the legislature, okay, or the executive in some jurisdictions. Okay, Sujit Chowdhury says that Canadian courts have struggled to articulate an adequate basis for according deference in some cases but not in others. And without clear criteria, necessity loses its force. So ironically, we can develop a strict standard of necessity, but then it's applied with a high level of deference, which leads to very limited. Our second strategy, often adopted, is it relates to a lack of evidence. The strict interpretation suggests that the evidence is required to show that a measure is necessary, right? Otherwise, if you don't have evidence to show it, then then the test is not very meaningful. But Chowdhury again says that public policy is often based on approximations and extrapolations from available evidence, inferences, and comparative data, and even educated guesses. So government may not be able to justify necessity to the high degree of certainty that it is the least restrictive means, right? And so one way to deal with this is that judges place the burden of proof on the applicant, the one who challenges the statute, and the statute is presumed to be constitutional. The presumption attempts to lessen the impact of the strict standard and address separation of powers concerns, right? That's one approach that some judges have adopted. But this is a real problem because it abdicates the responsibility of the courts to reason through the elements of necessity, and only to do so if the presumption is discharged. Rights should enjoy a presumption against limitation rather than one in favor of limitation, right? It puts the thing the wrong way round, and this flows from the very nature of rights as having strong importance. So any presumption of constitutionality doesn't make sense against a background if we understand what fundamental rights are, and it weakens those rights too significantly. So I hope I've provided you with some reasons why the strict interpretation of necessity focused on the least restrictive means is actually problematic, and it leads courts to adopt various forms of avoidance strategy. So we need in some way to reduce the risk that necessity will be avoided, okay, in a way that runs the risk of weakening the protection for rights. And the question then is, how then should necessity be approached? Okay, we saw that setting the standard too high and it often leads to analytical vagueness as well. And we need to outline what I've suggested is a moderate interpretation of necessity. Now, I'm not going to go into, some of you will know the work of Robert Alexi, who famously in a sense, systematized the thinking behind proportionality in his book, A Theory of Constitutional Rights. And I'm not going to go through the critique of him here, but let me say the problem lies in conceiving of rights as what he calls optimization requirements, norms that must be realized to the greatest extent possible. Optimization works for economic goods, but is vague and problematic in legal and moral matters. And when laying down the various aspects of necessity, I hope I will convince you of that point, right? And that requires a revision of his theory in some ways, okay? But I want to, for more importantly, for your purposes, to actually engage a little bit more with the four components. So the first component, right, is what I call possibility. A measure is only necessary if there is no possible alternative that will equally realize the objective whilst having a lesser impact on the right. And the question then arises, what is included in all possible alternatives? Okay? Well, clearly some understandings of possibility are too wide, logical, physical possibility, and they would leave too little room for limiting rights. We can always conceive of a logical possibility that would be least restrictive. What about something like practical feasibility? Well, that also has an uncertain scope, right? Economic scarcity is something we need to think about, political sensitivity, but it runs the risk of being too weak, right? You could always say, well, this is not politically possible. We won't protect the rights of this group because it's politically too sensitive, right? That's not going to protect rights enough. Possibility, importantly here, has significant variability, and it entails normative and substantive reasoning. We have to think about what we regard as possible. And if the test is to have bite, courts cannot simply defer this, right? And as Professor Grimm has suggested, the idea is in a way that the parties should place the leading alternatives before the court. You, in a sense, place an onus on the parties to lay out which possibilities they want to be considered, okay? Because otherwise it becomes a bit unmanageable. But nevertheless, one needs to think very carefully about this question of what alternatives are there. The second stage is what we can call instrumentality. Courts must look at the relationship between different means and ends to be achieved. And we heard the strict interpretation, the optimization interpretation, is that they must be equally effective. But this leads to the problems, right? The German Constitutional Court, it characterizes the purpose so that an alternative means will, in a sense, never be equally effective. And often the test loses its bite in Germany because of that. The Canadian Supreme Court reformulates the test, okay? And it asks whether the alternative means will achieve the objective in a real and substantial manner. And I want to suggest to you that if we want to make sense of this test, the Canadian approach makes much more sense than the German approach. The Canadian approach is more realistic and it makes more sense of the test, right? And so courts exercising discretion must consider whether the feasible alternatives realize the objective in a substantial or sufficient manner. Equally effective is just an impossible standard to meet and basically renders the test OTOs. Okay, impact. What is the impact of differing measures on fundamental rights? Well, this involves a qualitative normative judgment by courts, often without clear precision. And the problem is that courts often do not demonstrate a willingness to engage with the content of rights and the degrees of impairment. So it's very critical that we think carefully about what rights are implicated, what are the interests at stake, and to what degree are they impaired. These need to be in play in order to engage properly with the necessity inquiry. And as I say, to improve reasoning, courts need to think through those things carefully. Okay, that's true of the whole proportionality inquiry, by the way. And the last stage is what we can call comparativity. Necessity involves a comparative judgment. Is the measure the least restrictive of the feasible alternatives? And this requires an evaluation of whether an alternative measure exists that sufficiently realizes the objective whilst having a lesser impact on the right. We actually move from least to lesser, okay? And to understand this, we need to understand that there are two axes of this comparative exercise of what alternative is best. The manner of realizing the objective, what I call M to O, okay, and the impact on the right, which we can call R. And the judgment involved in necessity is whether there is an alternative that has a lesser impact on a right, but still achieves the objective in a real and substantial manner. So there is a comparative exercise here that, importantly, in the necessity level involves a degree of balancing, in a restricted level of balancing, but actually there's a degree of balancing in necessity itself. Okay? So I've put a formulaic way of thinking about this. It might be a bit too complicated to go through now. So I'm going to do it. I'm going to explain to you how I think about it through an example. And we'll return to that case, Amabungani, which deals with data surveillance of mass data by the intelligence agencies, right? Looking through people's mobile phones or their emails, etc. And the question at stake was, how long can the state keep intercepted data of private communications? And we consider 3 years or 6 years. Well, what's the objective? The objective served by storing surveillance data is to assist with ongoing investigations into serious crime and national security threats. Clearly a legitimate objective. What is the impact on rights? Well, the longer the communications data is retained, the more invasive the infringement on privacy and the potential for abuse of the data. Okay, so governments can get up to all terrible things the longer it is kept, right? So the shorter period, the lesser invasion on privacy. Okay? Now, alternative measures may both realize the objective in a substantive manner, but do it in a slightly better way than others. Okay? So when is that offset by the lesser infringement on rights? So 6 years might obtain the objective in a better way, right? The governments can say 3 years just doesn't achieve it. We won't have the data to protect crime for as long as we need. Crime doesn't only occur in a short period of time, okay? But it has a lesser effect on the right. And when is that offset by the lesser infringement on the right, okay? So less time for data storage, 3 years, has lesser efficiency to achieve the objective, but there's a greater gain to the right to privacy. More time, 6 years, achieves a greater efficiency for the objective, but has a harsher impact on rights. And in this stage, we need to balance the effect on the objective versus the lesser impact on the right. This comparative exercise demonstrates that a limited level of balancing becomes a component of necessity. Now, you might ask me, and this is a complex question, what's then the relationship between the necessity and the balancing stages? Okay? Does this mean that the third stage of proportionality is not important? Okay, and Professor Grimm has laid out quite effectively what he thinks goes into that and the legal side, trying to make it not a purely political query. But necessity ultimately doesn't answer the normative question of whether the benefits of the measure in the concrete circumstances, as Professor Grimm has laid out, outweighs the cost to rights. Right? Necessity doesn't answer that normative question. And in my view, that is the question for the third level. So in the case I gave you, even if we decide that 3 years meets the necessity test, right, rather than 6 years for keeping the data, one must still evaluate whether the benefits to security of keeping that data outweighs the harms to privacy of doing so. Okay? And that is a normative judgment that you have to make at the third stage. Okay? So, the moderate interpretation of necessity involves 4 components. Right? The strict also involves these 4 components, but it interprets them in a much stricter way. Right? All feasible alternatives need to be considered, with the court being explicit about their criteria of feasibility. Secondly, the relationship between the measure under consideration, the alternatives identified, and the objective sought to be achieved needs to be captured. And as I've suggested to you, the alternatives must substantially or sufficiently realize the objective, not equally. Differing impact of measures on fundamental rights must be assessed. And finally, there must be an overall comparison between the measure and alternatives and whether the government measure is best in relation to the 2 axes, objective and right, okay, which I suggested to you were the 2 axes. Now, just to suggest to you that it might sound to some extent theoretical as an attempt to bring down some of these ideas, but it actually has been adopted. My view, I was very happy to find, had been adopted in the Indian Supreme Court when they were faced by a similar challenge on privacy in relation to a national biometric identification scheme called the Aadhaar program. And the Supreme Court there actually brings proportionality into India. This is very recent, by the way, so it's very relevant to Tunisia in the last 5 years. And they needed to consider how to capture the necessity test. And they drew on my work on this, and as I've mentioned to you, we have a limited period. I know I'm almost straining that period now because it is complex. But you can read my piece, which I'm sure can be also circulated, called Necessity and Proportionality, in a book called Reasoning Rights, which will allow you to go through it in more detail. And the adoption of the necessity test concerned the government the court had to consider whether the government had discharged its evidentiary burden to show this national identity card was the least restrictive effect on privacy. And they adopted a more moderate interpretation of necessity, saying that the strict interpretation would make the test meaningless. And ultimately, they held that certain aspects of the card were constitutional, whilst other more intrusive ones, which were linking the card to bank accounts and mobile phones, were not acceptable. So that was kind of acceptable for purposes of people being able to get access to government services and grants, but not for purposes of deeply intruding into our personal sphere. Okay, so very interesting case in the India, and there have been 1 or 2 others that have also engaged with this as well. So in conclusion, right, fundamental rights are not absolute, yet they deserve strong protection. Proportionality is a way of providing a strong justification or a reasoning process for limiting rights. The necessity test is a vital part of proportionality. It requires an evaluation of alternatives and whether an objective can be achieved by less restrictive means. The way in which the necessity test is conducted can tend towards either rendering these rights absolute or offering them too little protection. And what I've suggested to you, and it will be I know Tunisia is in the process of defining its approach, so it's worth thinking about these things when these matters are captured, that a more moderate interpretation is possible, which affords significant protection for rights, but also allows for their limitation in suitable circumstances, right? And it's important to recognize that proportionality necessity doesn't eliminate the need for qualitative judgments. They cannot be eliminated from a determination of necessity, but a clear reasoning process of various stages can help guide the judgments that are made and hopefully also ensure that rights are protected to as great a degree. I hope it was clear enough to understand the core elements of the necessity test and look forward to some engaging in questions.
Thank you very much, David, for that presentation. That was really terrific. I'm very, very happy with the way in which this. Very much like to see in some time in the future is for discussions and comparative discussions about proportionality to also around the world, to also include discussion about Tunisian cases and developments in Tunisia, about the court decisions and the theoretical and scholarly developments here in Tunisia. I mean, obviously there's a slight language barrier because most of the work that's done here in Tunisia is in Arabic and to a lesser extent in French, but hopefully we'll be able to bridge that gap sometime in the near future. So I'd like to, we have around a half an hour for discussion. So if anyone would like to ask a question or make a comment, please let me know. Just raise your hand. We have an intervention right now. ممكن نوصل الميكروفون هون للأستاذ من فضلكم؟ في. أوكي طيب. شغال أستاذي؟
مش عارف.
اوكي طيب اوكي فاذا ممكن بس تقدم نفسك انه حتى الاساتذه يكون عندهم فكره وتفضل استاذي. شكرا.
صباح الخير الناس الكل. انا شهر الدين غزاله مدير عام بمصالح مستشار القانون والتشريع. كنت ضمن احد الاعضاء اللي تولوا اعداد ادله الاجراءات المتعلقه بالفصل 49 وهو الدليل المتعلق بالسلطه التنفيذيه. انا عندي سؤال للسي خالد الماجري وسؤال للخبير الألماني السيد ديتر جريم. سي خالد، بحكم أنت اشتغلت كثيرا على الفصل 49 من الدستور، هل ترى أن الفصل 49 من الدستور كما ورد في الصيغة متاعه هل هو ينطبق فقط الضوابط الموجودة في كيفية تحديد الحقوق والحريات تنطبق فقط على الحقوق والحريات الموجودة في الدستور كما نص الفصل 49 اللي هو قال يحدد القانون ضوابط متعلقة بالحقوق والحريات المضمونة بهذا الدستور، وإلا فما حجج قانونية أخرى نجم نستند لها باش نخرجوا من القراءة الضيقة للفصل 49 باش نقولوا أرى الفصل 49 ما ورد في الفصل 49 هو فلسفة عامة متاع حقوق وحريات يمكن أن نرتكز على حجوج قانونية أخرى القول بأن الفصل هذا ينطبق حتى على حقوق أخرى، خاصة أن فما حقوق أخرى ما ذكرتش وحريات ما ذكرتش في الدستور التونسي على غرار مثلا حرية التجارة والصناعة اللي هي ما ذكرتش صراحة في الدستور. به والسؤال الثاني للسيد الخبير الألماني السيد ديتر جريم فيما يخص بحكم هو اشتغل أيضا على بينة معناتها حسب التقديم تاعه بالفصل 49 في الدستور التونسي. هل أن المشرع الدستوري التونسي عندما اختار التنصيص على أن الضوابط لا توضع إلا لضرورة تقتضيها دولة مدنية ديمقراطية من خلال التجارب المقارنة وخاصة التجربة الألمانية، هل أن المشرع الدستوري كان على بينة عندما اختار عبارة الدولة المدنية الديمقراطية وليس المجتمع المدني الديمقراطي؟ هل أن في الدول المقارنة نفس التوجه اللي هو الضرورات التي تقتضيها دولة مدنية ديمقراطية، وإلا ربما فما الدول المتقدمة في مجال حقوق الإنسان ربما المجتمع استبطن منظومة الحقوق والحريات ويمكن أن نتحدث عن ضرورة يقتضيها مجتمع مدني ديمقراطي. شكرا.
الأستاذ خالد وبعد ذلك الأستاذ جريم من يرد مباشرة. إذا كان فما أحد ثاني إنه يحب أن يوجه سؤال بس أعطوني.
لكن أنا نحبذ أنه نفهم هذه نفهم كلمة هذا بالمعنى المادي للدستور مش بالمعنى الشكلي. معناها في هذا الدستور أي في هذه الوثيقة التي تضمن الحقوق والحريات. والكلنا نعرف أن الوثيقة الدستورية التي تضمن الحقوق والحريات ما هيش مجرد وثيقة، بل هي منظومة حقوقية كاملة من منظومة حقوق الإنسان ككل اليوم في تونس. أنا نحبذ أنه الفهم يكون هو الفهم الواسع لهذه الكلمة، مش هذا الدستور فقط، إلا بخصوص معناه هو باش يطبق على جميع الحقوق والحريات، لأنه الهدف معناه اون ليكتور تيليولوجيك نتاع الفصل 49 ما تنجم تؤدي الا الى هذا، لانه معناها الاكزيجيز هوني ماهيش ما تحيلناش الى روح الفصل 49 والى روح الدستور نفسه، اللي بطبيعه الحال الدستور عندما يضع حقوقا لتلك الحقوق فقط، وانما
يمكن مثلا ان نرتكزوا مثلا على الديباجه نتاع الدستور اللي هي تقول تعبيرا عن تمسك شعبنا بتعليم الاسلام ومقاصده المتسمه بالتفتح والاعتدال وبالقيم الانسانيه ومبادئ حقوق الانسان الكونيه الساميه. ومن بعد نجو في الفصل 145 يقولوا توطئه هذا الدستور جزء لا يتجزأ منه. حكينا على حقوق الانسان الكونيه معناتها تكون مش موجوده ديجا، فما بعض الحقوق الانسانيه الغير مضمنه في هذا الدستور. والفصل 146 اللي يقول تفسر أحكام الدستور ويؤول بعضها البعض كوحدة منسجمة. باش نرتكزوا على الحجوز هذه باش نقولوا الفصل 49 يجب يطبق أيضا على حقوق وحريات غير مضمنة صراحة بالدستور.
Je suis tout à fait d'accord, oui.
There was a second question, therefore, for Professor Grimm. So the question, Professor Grimm, just in case it's helpful, was about the wording in Article 49.
I don't know, of course, what the Tunisian Constitution maker had in mind when they formulated acceptable or compatible with a civic and democratic state. But if I try to make sense of that formulation, I would probably say entitled, but the government is bound, and so I find it reasonable to speak of a civic and democratic state, and I don't think that exchanging the term state for society would bring any improvement.
Okay. Thanks, Professor Grimm. I don't know, David, if you want to contribute to that question as well. If so, just give me just let me know. Otherwise, I'm going to pass on. So Professor Selwa is going to ask another question. So إذا ممكن تقدمي نفسك كممنون.
شكرا زيد. سلوى حمروني، أستاذ تعليم عالي في القانون العام والخبيرة المشرفة على الأدلة. قمت بصياغة الدليل القاضي الدستوري أيضا. عندي سؤال pour le professeur Grimm et peut-être un ajout par rapport à ce qui a été dit par Shahreddin à propos de la Constitution ou des droits qui sont visés par l'article 49. J'ajouterai juste l'article 21 Shahreddin اللي هو يقول تضمن الدولة الحقوق والحريات العامة والفردية. دونك يعني العبارة مطلقة يمكن أن تبقى على إطلاقها. سؤالي Est-ce que je peux poser la question en français? Il y a de la traduction, donc oui. Alors ma question, c'est à propos du droit allemand, en fait, et de la jurisprudence de la Cour constitutionnelle allemande à propos de l'article 18 de la loi fondamentale. Pourquoi je pose la question? Parce que c'est un article qui décide de la déchéance des droits fondamentaux lorsqu'il y a un abus de la liberté d'expression, des opinions, de la liberté de la presse, la liberté de réunion, d'association, ainsi de suite. Donc l'abus pour combattre l'ordre constitutionnel libéral et démocratique. Lorsqu'il y a un abus dans ce sens, la personne est déchue de ses droits fondamentaux et la déchéance est prononcée par la Cour constitutionnelle. Ce qui me paraît être très très intéressant, mais aussi très lourd de conséquences en termes de droits et libertés, parce qu'on parle de déchéance et on ne parle pas de limitation des droits, on parle de déchéance des droits. Donc voici ma question pour le droit allemand. Merci.
شكرا أستاذتي سلوى. Professor Grimm, go ahead.
Shall I answer directly? Yeah. First of all, Article 18 of the German Constitution has never been used. We have no court decision and we have no application. I think there were a few applications, but they didn't reach the stage of decision making. So my answer can only be a hypothetical one, whether the proportionality test would apply in case of Article 18. But I can try to answer your question by using a different article. There is not only in the German constitution the possibility to deprive certain persons from their rights when they abuse them in order to overthrow the democratic government, but we have also the possibility to ban political parties when they attempt to overthrow the democratic system. And this norm has been applied several times, not very often, but several times. The original interpretation was that the proportionality principle does not apply. It is sufficient that you can prove that there is an attempt by a political party to overthrow the democratic government. But in the most recent example, that was a case on a required ban on the National Democratic or extreme right-wing will apply the proportionality test and will not only ask, does this party try to overthrow the democratic system, but is there a real chance that they will do it? And if the chance is minimal, then it would be not necessary. Step number 3 of the proportionality test to prohibit the party. So this extreme right-wing party was declared to have unconstitutional goals, namely to overthrow the government, but under present situations, they don't have the slightest means to be successful with this. And so I could imagine that the case of Article 18 arrives, probably the same test would be applied. But this is a guess.
Thanks very much, Professor Grimm. So if it's okay with everyone, I'm going to ask a question. And if anyone would like to ask a question after me, please let me know. So my question is prompted by something that David Bilshit said. So maybe, but I would like to hear what all three speakers think about this. But maybe we could start. What's prompting the question is what you said about evidence. And you quoted Chowdhury, who was getting some feedback. I don't know where it's coming from, but anyway. Okay. You quoted the Chowdhury on evidence. So when appearing before a court and arguing issues of proportionality, a court might say to a representative of the state, a lawyer arguing on behalf of the state's position that a law is proportional, and say, well, what is your evidence that this is actually necessary? Right? What is your evidence? And the quote from Chowdhury that you cite suggests that on many occasions, not much is required in terms of evidence from the government, and that what I think the term that Chowdhury uses is on most occasions or on many occasions the government is just engaging in educated guesses. So my question is whether or not there's an evolution that's taking place, but what we suspect is so on and so forth. And it's less, and that could therefore be used to advise, and also how the vaccines can be distributed as well. And I suspect that court cases where policy is being challenged for vaccine distribution and restrictions of movement are forcing government representatives to speak more specifically about the evidence that exists about how the pandemic is impacting people. I suspect, but I don't really know. So my question, and once again, if David, you could start by speaking to this, that would be really terrific, is how much evidence is really required, and are things changing with time? Please go ahead.
Great, thank you very much, Zaid. I hope I don't see I'm coming up. For some reason, the video seems to be weak, but...
well, we can see you fine.
Oh, there we go. There we go. I can see. It's a really important question because because the process of proportionality is meant to be a process of justification, and if any evidence surfaces, then rights are going to be very weakly protected. So we call this the epistemic dimension, or the knowledge dimension, is actually another aspect of proportionality. And Robert Alexi famously comes up what he calls a second law of balancing. And what is the second law of balancing? The more heavily an interference in a constitutional right weighs, the greater must be the certainty of its underlying premises. So in other words, the stronger the interference with the rights, the more you need to know more, you need to have stronger grounds, you need to have stronger evidence to ensure that you are doing so on a justifiable basis. And that is very important. It's often not thought about. It's just thought about generally. But what, Zaid, you've also drawn attention to is that our knowledge will also grow and depend on various circumstances, right? And it might not be reasonable to require a certain amount of evidence in some cases. But actually what proportionality should do is it should make us suspicious about certain kinds of certain kinds of claims. So, for example, it was claimed that not having gay soldiers in armies in Europe will reduce the morale of the soldiers, right? For which there's literally no evidence, and it's nonsense, we know, and one should be very suspicious about such kind of claims. And so we need to make sure that the claims relating to proportionality are not based, in this case, for example, on prejudices, right? And that one actually asks for some reasonable basis, but you can't ask for more than is required. So I think that's what Chowdhury is trying to say, is that public policy may not be absolute. You might not be able to get absolute clarity. There's a case in Germany, Professor Grimm, I'm sure, is very familiar with, about tobacco advertising and ensuring, and actually around the world today, of requiring tobacco companies to put warnings on the cigarette packets. And at the time, it's quite hard to show social scientifically that is the best measure that can be done to reduce smoking, right? It's a very hard thing, but it seems quite reasonable that people seeing horrible pictures will, in all likelihood, have some negative reaction, and that it might deter, in some sense, not be an absolute barrier, but deter in some sense smoking. So, as I say, this is a complex area. I think the key point about evidence is it cannot be on the basis of no evidence. There has to be a reasonable case. And as Alexi said, the more intrusive the interference, the greater certainty there must be.
Thanks, David. Professor Grimm, could you offer your thoughts about this?
I totally agree with what David said. And I would once again repeat what I said, that the court, in cases that are very important and where knowledge is not directly available or directly convincing to judges, that they can invite experts. And the German Constitutional Court
في الحقيقة هذا هو الضمانة بالنسبة للمتقاضين، للأفراد أصحاب الحقوق، وهذا أيضا ضمانة للمشرع، لأنك أنت وإلا حتى للسلطة رجع ونعملوا في مجلس نواب ونعملوا في مجلس تشريعي باش يحط القوانين. سي با سا لو رول دو جوج. لو رول دو جوج أنه يتبع لو تيست هذا. وكان نلاحظوا حتى في فقه القضاء المقارن، معناها الكندي وإلا الجنوب أفريقي وإلا السويسري، نلاحظوا أنه غالبا ما يسقط، إذا كان مش تسقط لا مزور، تسقط في المراحل الأخيرة من الاختبار. جينيرالمون يا إما في لأنه قليل وين ولا القاضي في حد ذاته ما يسمحش لنفسه مثلا أنه وقت اللي يرى فما علاقة ممكنة بين الهدف دونك هذا علاش باش تعطي ايضا لاتيتود للي بوفوار باش ينجموا يتحركوا. اذا كانوا موجود سون شوا الي دون اون غام، وهذا كلام المحكمه الكنديه بدا يقول دون اون غام راسيونيل دو شوا، اون غام راسيونيل نتاع دي شوا بوسيبل، يتعدى من المرحله نفسه. وهذا علاش هو معناها نقول انا اليوم باهي الفهم موجود لمبدا التناسب، لكن على مستوى التطبيق معناها أنا معناها كان جيت تعمل إحصائيات يمكن في فقه القضاء الكندي ولا السويسري ولا غيره، معناها تلقى لي كا أو il y a eu معناها refus de la mesure. فهمتني؟ ils sont assez rares quand même. معناها مش ديما، معناها مش القاضي سامبلومون معناها باغ واحد ان تيست دو واحد كوش هكايا.
المساس بجوهر الحق هي مسألة بعدية، أي بعد التطبيق المراحل الثلاثة، أم يمكن قبل تطبيق اختبار التناسب الحكم أو الإقرار بالمساس بجوهر الحق، وذلك لأن نعرف أن المساس بجوهر الحق هو معناها عدم دون قيام بالإجراء معناها الضرورة، دون النظر في الضرورة، دون النظر في الملائمة، لأنه إذا شفنا من الأول أنه الحق تم إن شأن التعبير حذفهم، إذا نرى أن اختبار التناسب في مراحله الثلاثة يكون هنا من باب التزايد شأن التعبير. وشكرا.
شكرا أستاذ الكريم. I think that's going to be the last question before we wrap up, because we're just about out of time. So what I'll do is maybe we can ask the speakers to speak in reverse order, in the order in which they spoke. So maybe David, if you could start, and then we'll pass on to Professor Grimm,
Okay.
and then we'll pass on to and then we'll pass on to Professor Khalid. And if you could also just offer some closing thoughts while you're speaking as well, that would be terrific. So if there's nothing specific that you want to say in response to the question, but offer some closing, please, David, go ahead, and then we'll pass on to Professor Grimm, and then to Professor Khalid. Please go ahead.
Thank you very much, Zaid. And let me also just congratulate International IDEA on this conference and taking proportionality and trying to give greater content to it and engage internationally with a comparison. In Tunisia, I look forward certainly to comparing and engaging between the South African approach and the Tunisian approach and others in the world. So I'm looking forward to the jurisprudence in Tunisia coming through, and for you yourself to develop the test and engage with it in a substantial, meaningful way and protect rights. In relation to the question, let me say, and Professor Grimm will, I'm sure, address this in Germany. My view is that the essence of the right test requires one to have an understanding of the interests that are protected by the right. So we need to think very carefully about what are the most important interests that are protected by the right, and where those interests are totally obliterated, then there will be no possible justification. And actually, it does not matter in some ways whether or not it's done in proportionality or before. Why do I say that? Because proportionality will not allow an utter obliteration of a right, usually, right? Because there are some interferences with a right which weigh so much that no possible objective could justify interfering with those with the right in that way. And so it seems to me that the essence of the right requirement is really meant to capture that idea. It's meant to capture the idea that if you fundamentally obliterate, essentially kill, for example, someone, I mean, survival is obviously the most basic condition of having rights, okay? But if you've got a right to privacy and you put a camera in every person's room in the home and you allow a person no space in which to exist with any privacy and the state is surveilling them all the time, that would seem to me to be an obliteration of the right to privacy. And the essence of the right would the idea that you can control some space relating to your own life would be completely taken away. So the essence of the right requires us to think and identify normatively the most urgent, serious interventions of the right, and to say that there will be no possible justification that can succeed in achieving those. And now there are obviously very complex limiting cases of self-defense, if we can kill someone in self-defense and various things like that. So there will be some cases where you might want to protect one essence against another essence. right? And those will be some really hard cases. But in general, the rule of thumb, even within proportionality, will be that restrictions that are so absolutely onerous will never pass muster. So I think that is a good segue into a concluding remark of just to say, I think it's important to recognize that proportionality is not there to do it just for its own sake. It is ultimately there to strengthen the protection of fundamental rights and to ensure that, and it is justifiable. I'm a human rights lawyer, fundamental rights lawyer. I think there are cases where it is justifiable to restrict rights, but it must be done very carefully with a proper justification. And a little plug, Jay talked about my own book, and this is the next stage perhaps in Tunisia. I think this also applies, by the way, in restrictions on rights in the private sector, where businesses and other private sector interfere with the right. But that's a different topic, but it's something I'm writing on at the moment, so something of interest perhaps for a future presentation. So thank you very much for having me, and wishing you all the best and all to stay healthy as well over this difficult time.
Thanks very much, David. Professor Grimm?
I will try to give a pragmatic answer to that question. I think it is extremely difficult to define what the very essence of a right is. But it is much easier to apply the proportionality test. And for me, it's hard to imagine that a case that passes the proportionality test can present a violation of the very essence. So my pragmatic answer, although it is not in the line of order how Article 49 is composed, my recommendation would be, place it at the very last moment. Ask this question, the last question, and you will probably never find a violation of the essence clause if you have applied the proportionality test properly before. For Germany, I would say, and I mentioned it already earlier, more or less the essence clause, Article 19, has become obsolete because of the intervention, the earlier intervention of the proportionality principle. But I agree with David, there may be some very extreme and extremely rare cases where the essence clause could play a role. So I don't recommend to forget about it. But I think in all normal cases, you will come out with a good solution when you apply the proportionality test. And again, thank you for having me with you, and all the best to the participants. I remember quite well and with affection my first visit to Tunisia 2 years ago.
Thank you, Professor Grimm. I'll pass on now to Professor Khalid, who will be the
شكرا.
final thoughts.
أثار صديقنا مسألة مهمة جدا، مسألة ما يحكي هذا ولا أثار صديقنا مسألة مهمة جدا، وعكس ما يبدو من أنها مسألة سهلة ولا واحد، مسألة المساس من جوهر الحق. والمساس من جوهر الحق هي من المسائل المعقدة كثيرا، لأنه يمكن كان نجم نعرفوا كل المراحل متاع اللي كنا نحكيو عليها في الفصل 49. ما هو جوهر الحق؟ تعريف جوهر الحق في حد ذاته يطرح إشكالية. يمكن أن نعود مثلا إلى الفكرة اللي الأمم المتحدة تكرسها ولجنة حقوق الإنسان تكرسها، أنه انقلاب الاستثناء إلى مبدأ والمبدأ إلى استثناء. لكن كل هذا يلزمنا نفهموه في سياق التفكير في هذا المفهوم، مفهوم جوهر الحق، في سياق التفكير في جوهر متغير للحق حسب الحالات وحسب الظروف. فهوني on est obligé de passer à l'étape suivante. حاجة أخرى، هو المساس بجوهر الحق في آخر الأمر هو تناسب غير معناه تناسب من كثرة هو عدم تناسب صارخ. المساس من جوهر الحق هو عدم تناسب صارخ. هو معنى إلى العلاقة بين دونك الكونفوزيون بين جوهر الحق واختبار التناسب، وفما شكون يفصل. معنى المسألة معقدة. معناها هذه في تونس أنا نجم نعتمد على قرار جديد توقيف تنفيذ. قبيله ذكرت نتاع 26 ماي، هذا قرار في 12 جانفي 2021 توقيف تنفيذ أيضا محكمة إدارية، يقول أن المساس من جوهر الحق يتم بصورة من صور ضروريا لانه مش سهل. معناها القاضي باش يجي يقول اسمع هذا والله يمس من جوهر الحق تعدى، بأن معنى مس من جوهر الحق. شكون قال انه اللي باش يسمع الرأي هذاك باش يقول لك اي.
طيب شكرا جزيلا جميعا. راح نرفع الجلسه. اود انه اول ما كان عندنا الفرصه ان نراكم هون في الاراضي التونسيه، ولكن نتمنى انه تقوموا في زياره قريبا على تونس بعد ما كنا نحن حصلتوا على اللقاح وكل شيء كان تمام. ولكن انا